program Current Affairs, now we bring you a discussion on important bills passed in the Parliament. The participants are K.V. Prasad and Shivaji Sarkar, political analysts, and Ashwini Srivastav, journalist.
Parliament's winter session, which began on December 4, is over. Parliament was adjourned sine die on Thursday, a day ahead of its schedule ending, and 3 frenetic weeks that saw a security breach in Lok Sabha, suspension of 146 MPs, and the expulsion of Trinamool Congress member Mahua Moitra in the bribe for query case. During the session, both the houses approved some key bills such as those to replace colonial era laws, Indian Penal Code, Indian Evidence Act, Code of Criminal Procedure, Telegraph Act, and Press and Registration of Books Act. Lok Sabha Speaker Om Birla had said the House recorded 74% productivity and 18 draft legislation, including the new criminal justice bills, were passed. Rajya Sabha Chairman Jagdeep Dhankar had said that the upper house was able to transact business for 65 hours during the 14 sittings. Let us talk about the bills that were passed in this session. K.V. Prasad sir, let us first talk about the Telecommunication Bill 2023. The bill seeks to replace the Indian Telegraph Act 1885 and the Indian Wireless Telegraphy Act 1933. How do you see this bill? What are the salient features of this proposed legislation?
I think it's very clear that the government is moving towards a regime which, in terms of lawmaking, which keeps up pace with the change in technology and the way in which communication industry has evolved over the past many years. Especially, it has taken a leapfrog, and the technology is changing ever so often, and new kinds of services are being offered to customers, to people at large. The kind of delivery mechanisms have changed, the delivery platforms have changed, and so as a usage. So I think this telecom bill moves along on those lines to try and bring certain guardrails which are necessary. And the biggest thing, of course, is, as we all know, they talk about they abolished the rules, as you said, some of the made as early as 1885. So if you look at the kind of technology that was available in 1885 and we come to this 2023, there's a huge difference with what's available. In addition, of course, the biggest thing we all know is that kind of gives the government, in case of a national issue, it can take over the telecom services and take control and monitor traffic data in national security interest, which is something understandable because there's a certain ways in which you envisage when there's a national security and also certain services that are being provided. I think what's being looked at is the kind of issues that have been crept into this bill, which require certain amendments to the existing laws. And I think the biggest takeaway that I look at is they're trying to bring some kind of open up room for what is understood as a satellite-based services, because some of the bigger players in this telecom industry are trying to move on, offer that kind of a service vis-a-vis what's being available to us. So I think that's one big takeaway, Ashwin.
Right. And now the authorization will be required from the central government to establish and operate telecommunication networks, provide telecommunication service, or possess radio equipment. Spectrum will be allocated through auction except for specified entities and purposes for which it will be assigned administratively. Shivaji sir, would you like to add something more to this bill's feature?
Yes, one thing we have to see, those bills which actually now have been virtually subsumed by the new telecommunication bills. If you see that whether Telegraph Act 1885 or Wireless Telegraphy Act, Telegraph West Unlawful Accession Act 1950, as also TRAI Act, that is the Telecom Regulatory of India Act 1997, I would say there is one thing that all these bills, if you see, they have kept with the changes in the technology at different times. And in this particular case, as we see, that the various kinds of the provisions that have been made into the telecom related activities, that prior authorization of the central government will be required, provide telecom services, establish, operate, maintain or expand telecommunication networks, and possess radio equipment. So there is a kind of conditions that there has to be a prior authorization of the government, which was exactly not so in the earlier bills, though it also indirectly provided, but there was not that kind of a direct system here. Then about the assignment of a spectrum, if you look at it, it will be assigned by auction, and except for specified uses, it will be allocated for an administrative basis. So there are issues in that also it mentions that these include purposes such as national security and defense, disaster management, weather forecasting, transport, satellite services such as DTH and satellite telephony, And BSNL, MTNL, the public services, will continue to function as they have been, or perhaps with far more efficiency. The central government can repurpose and reassign the frequency range as well. So the government keeps lots of powers with it, and especially because it is an evolving area where satellite telephony and satellite systems will also come on, as KV also mentioned. So we find that in this telecom bill, there are lots of issues that have been virtually on the periphery that has been brought directly into it, including the Telecom Regulatory Authority of India, which is virtually now has been a separate bill and separate way it is to function in a particular manner. Now that has also been area of the new telecom bill. So it also specifies how these appointments are also to be made in the TRAI. One interesting aspect that includes is the Digital Bharat Nidhi. That is a very important issue. This is a virtually kind of universal service obligation fund. It has been established in reality in 1885 Act, but it continues with telecom services and it will provide services in very difficult areas. That is the purpose. This bill retains this provision and has renamed as Digital Bharat Nidhi.
And one of the interesting features of this bill is that it provides the central government, clearly mentions that the central government may provide for measures to protect users, such as requiring prior consent to receive specified messages and creation of a do not disturb register. How do you see this, Shivaji sir?
This provision is already there in some way or other in the present system also. Now, what the government is trying to make it a part of virtually the entire omnibus telecom bill that has come out. So now, in a way, those unwanted calls and those which are virtually disturbing people and also intruding into privacy, those can be controlled and checked. And if somebody doesn't want a call, then he cannot make a call, and it now would be also punishable in one way or other. That is the various offences that it speaks of.
Kivir Prasad sir, the key issues related to the bills were those on interception and mass surveillance. Do you see that the proposed legislation is addressing them, the issues of interception and mass surveillance?
Well, that has been introduced in the bill and it remains so. In fact, that has been one issue that some people have already flagged as an issue that can affect the privacy of conversations, especially on such platforms. So this is something which, even though the government has assured that there's nothing of that kind that's in the offing, but in kind of national emergency, it's a situation where it's a different thing. So that is provided for oversight that the government would like to keep. And in fact, much of what Mr. Shivaji Sarkar also mentioned, the government has kept a lot many oversight mechanisms with itself, which in turn lead to the situation where how do they play out when the situation so arises, something to which Mr. Sarkar also alluded to, Ashwini.
Let us now talk about the National Capital Territory of Delhi Law's Special Provisions Second Amendment Bill 2023. It was introduced in Lok Sabha on December 13. Now the bill amends National Capital Territory of Delhi Law's Special Provision Second Act 2011. How do you see this amendment and what's new in the bill?
Yeah, I think this bill, Ashwini, is providing for protection from any action for various unauthorized developments in the National Capital of Delhi. Now, this includes people who live in the slums and shanties, the hawkers, colonies which have come about unauthorized manner, schools, religious and cultural institutions, and agriculture godowns. These have been specifically mentioned. We all know over the many years, past many decades, in fact, Delhi has grown as a city. Many times it has grown under a planned city, but certain times some unauthorized areas have come up and now people have started living there for decades. And over a period of time, they live without proper habitable conditions. And at times, governments of the day, be the center, allow these unauthorized colonies to be authorized, thereby providing them civic amenities so that they become part of it because they've started living there and growing. So I think these are issues that need to be attended to. And that's why this National Capital Territory, Delhi Special Provisions, Second Amendment Bill is what was cleared by the Houses, Ashwini.
Shivaji sir, how would this bill help people of Delhi? In what terms? What relief can people of Delhi expect out of this bill?
No, see, these are certain things already in existence actually that have been virtually again covered by this. So there are certain new provisions as well. But I think one of the most important aspect of the bill has been that the powers of Lieutenant Governor has been specified in this act, I think this codifies one aspect which was perhaps slightly in the gray area. And now you see what it does actually. Under this act, matters where the Lieutenant Governor can have his discretions are mentioned. These are matters outside the legislative competence of the Delhi legislature, but which have been delegated to the Lieutenant Governor, or matters where he is required by a law to act in his discretion or exercise any judicial or quasi-judicial functions. So the bill specifies that in the various kinds of these matters, the Lieutenant Governor will act solely on his discretion. That means he need not consult the Chief Minister or the Delhi government. And this discretionary role is virtually expanded the functioning of the Lieutenant Governor by giving him powers to approve the recommendations of the authority or return them for consideration. We have to see how it shapes up, maybe in the course of a time, about how this Delhi state will function and what kind of restrictions will remain on the Delhi government and its chief minister and the cabinet. So these are some of the issues, I believe, that are being specifically being mentioned.
KV sir, the Jammu and Kashmir Reorganization Second Amendment Bill, which was also passed in this session, and this bill was introduced in Lok Sabha on December 12. Now the bill amends the Jammu and Kashmir Reorganization Act 2019. Can you please brief on the main act and about the proposed legislation? Both things. What is the necessity of bringing in amendments in the main legislation now?
One, I think this provides for the reservation for the women, right?
Right.
So I think post the changes that the Government of India made by the passing of the Nari Shakti Vandan Act in the special session of Parliament, since we have a union territory of Jammu and Kashmir, where in particular they were looking for the extension of that segment. That I think has to be done through, because otherwise if and when already there are plans that there would be an assembly election in the state. So when you have it, so you kind of look at it so that it comes in place automatically. So that extension would give you that kind of a facility where this act will be applicable to the particular section. So this was one of the reasons, if you remember, the Jammu Kashmir Reorganization Act, it was a thing. Also, I think the number of seats that were allocated. So that was the two areas that the government wanted to do. And since it's a union territory and as you're preparing for elections, as it were, you also have provisions made in terms for the migrants who have been, I think one of the provisions that specially brought in was for the people who have been displaced, the Kashmiri. So there are two specific seats who have been nominated category, including one woman. I think at the time this particular act was mentioned about, it was very clear a large-scale migration took place when there was in the 89-90 period. A lot of people, Kashmiri Hindus and Pandits, had to leave that place along with some other communities. So they located themselves elsewhere. So I think this was kept in keeping in mind to provide this whole thing, and so Kashmiri migrants and displaced persons, their interests were well protected by this. Ashwini.
Let us now talk about the three criminal law bills, the Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita and the Bharatiya Sakshya Bill. These bills will replace the Indian Penal Code 1860, the Code of Criminal Procedure Act 1898 and the Indian Evidence Act of 1872 respectively. KV Prasad sir, what is the new in these bills and how important are these three proposed legislation for the country and for the people?
Well, I think Ashwini, as the Home Minister, have made it point very clear that this is the first time the country's Indian Parliament has enacted laws for Indian, the one to replace two British acts with the colonial legislation that have been followed in terms of criminal procedure and also the Indian Penal Code. So these have been replaced. The Bharatiya Nyaya Sanhita 2023. I think this has made some 20 new offences have been added, while 19 have been deleted, is what we get to know. And also, I think they have brought punishment have been raised in case of some 30 odd offences and fines in case of some 80 odd offences. And for the first time, I think they have introduced something called a community service as a penal action, which means for a certain 6 offences which have been identified, which once you're convicted of that offence, one of the judgment would include something like offering a community service to get out to kind of serve that sentence. So that's one thing which is something come up new in this thing. I think most important, if you look at it, some of the major changes that have been introduced is how the definition of a child, definition of transgender, including gender itself, new chapter against women and child. So some of these highlights will bring, and they've also deleted was a section known as attempted suicide. And in important is we all know terrorism and how India continues to fight against this kind of the scourge. So terrorism is defined clearly in the same lines as it was defined in the UAPA and made punishable. In addition, I think what has been added is the economic security, the monetary stability of the country, which will constitute a terrorist act, because nowadays a lot of things can happen, especially if people are all aware of a cyber attack, something which comes through which can destabilize or a monetary. So all these are issues that we are looking at. Whereas the Nagrik Sunraksha Sanhita, again, it has added some 9 sections, almost nearly 40 subsections and clauses have been added. Some 177 provisions have been modified, 14 have been deleted. I think also keeping in time, space and kind of technology, audio, video, electronic videography have been introduced to infuse transparency and accountability in delivery of justice. Now that is something very important, because what we heard the Home Minister tell us in Parliament, that right from the inception of a FIR till the delivery of justice, much of it will become some kind of on the digital platform. So there is a level of transparency and people can get to know of it, because no longer you don't know if FIRs are filed somewhere and people get to know of it much later and things like that. And most important, if you think, is kind of, we always, as one of the papers put it, or very famous, a tariq pe tariq kind of thing. That means you get delays, adjournment of the case. I think there have certain time limits have been imposed, Ashwini. I think there'll be more as we can go ahead.
Right. The definition of sedition from Rajdroh, which is offences against the government, has been changed to Deshdroh, which is offences against the nation. And this particular aspect was mentioned by Home Minister Amit Shah himself in the lower house. How do you see these changes in the proposed legislation, and what's the importance?
Well, I think on the issue of sedition, we all know that this matter was engaged the highest court, and the government had mentioned about the fact that it is taking a look at this whole law. So I think that's why in particular this issue was mentioned, that sedition as such has been taken away, the clause that, and Rajdroh used to be against the state. Now, I think that has been, Deshdroh is a much wider concept. So it's a country, and the thing is here that has been brought in. So this is a very new clause that has come in, I think. So that's, people need to look at it as to what kind of actions will be governing this when it actually rolls out to play. Because certain sections of society have expressed concern. There have been a few editorials in a couple of papers this morning which point out to this clause, saying that it leaves room for certain issues. So I think that will be taken up as we go along, because this act has just about been passed in Parliament, and it will, by the time it converts into a law, this is the presidential assent, it's expected to in a few days, and then whatever rules that need to be applicable to it come forward. So I think this, we have to see how it comes. But primarily, if you look at it, the issue, as I said, sedition, where the matter was seized in the highest court of this country, the Supreme Court, and the government had made its thing over there. So this follows that line of thinking, is what my understanding is, Ashwini.
The bill has proposal that statements received electronically included in the definition of evidence. So they will be the evidence now. How important is this?
I think, actually, as we all know, that technology has evolved, so has this thing kind of, we have evidences coming up. Now, all of us know that ever since in the last 3 years, when we were all hit by the pandemic, how the world had moved from online more so. People have started working away from distant places. So I think all this technology needs to be, and some cases it may be already available, but to remove an element of doubt, because when you go for judicial, it goes before the judiciary and it kind of is examined by a court of law. You have to make sure that evidences which are admissible, because that cannot be contested. For instance, we all know that email long before many years ago it was given as it was an admissible evidence, so say email records. So similarly, you had to make sure that electronic records become part of it. And as I said right in the beginning, as also the Home Minister has himself made it, from the point of filing of FIR to the end of it, where it goes through the judicial processes and the judicial system, the whole thing can have an electronic trail. So I think that's one reason why, as I said in another context, it is also keeping up with times. So that's where it comes in, Ashwini.
Right. We are talking about these 3 proposed bills on criminal laws. The Home Minister in Lok Sabha had said that this full implementation of the proposed 3 new criminal laws will make the Indian judicial system the most modern justice system in the world. How do you see that is happening through these proposed bills?
You see, basically, again, you see what the Home Minister is saying, that making the court digital and all that. Courts itself has taken many of the states to do it. They have already gone during COVID times, online hearing processes and all that. Now you see, only the legal umbrella had to be provided. That has been provided. And what Home Minister says is not incorrect in that it will provide a new kind of a judicial system. Virtually, it is in vogue, but that's a different issue. But again, despite being in vogue, certain times we have to put it in the legal framework. That has exactly been done in the new process.
Right. Let's talk more on this Bharatiya Nyaya Sanhita, which will replace IPC. Here, now new offences like organized crime, terrorist act, petty organized crime, hit and run, mob lynching, hiring child to commit offence, sexual exploitation of women by deceitful means, snatching, abetment outside India, acts endangering the sovereignty, integrity and unity of the country, publication of false or fake news, etc. have been introduced. How do you see such changes which have been proposed in this bill? Shivaji sir?
You see, again, these are the various provisions in the law that have been included now. In fact, what happens when it is not that these issues are not being heard in the courts, but when it is heard, court feels that sometimes they are constrained because of the lack of exact provisions in the law. So for that smoothing of that process, these have been included into the new issues of the various kinds of that processes that are there, so that the courts are at ease in deciding and discussing the issues which are already before them. Because otherwise, sometimes what will happen, it depends on the presiding officer of the court how he will take it or not, or whether he will refer it to the higher court or how it will be done. So now that grey area has been removed and it has been made simpler so that the courts can function in an efficient and uninterrupted manner.
Right. KV Prasad, beside this, beggary has been introduced as a form of exploitation for trafficking under this bill. How do you see this as?
I think it's a laudable move because we all know that there have been, we have read reports, we have been a journalist and we all track stories at many a time. We have read, and there have been even Indian movies have been made about how beggary has been made up in a form of exploitation. People have been forced to beg, they've been maimed, their body parts have been injured to kind of make, so, and there have been organized gangs behind it. We all read stories, there have been police cases about it. So I think, as Mr. Shivaji Sarkar also put it, the fact that if there is a lacuna in law which allows people to get away or which makes it difficult for the courts to kind of step in. So I think all this takes care, and it's a social welfare measure. The whole thing is where the government is a welfare government. So it takes care of this. Seeing this couch being made in which is very much seen especially in cities and temple towns, elsewhere, travel places, tourist places, we find these beggars. So I think just talking beggary as an offense was already there, but here the people who introduced beggary as a form of exploitation for trafficking, I think that's something which should be seen as a good move.
Right. KV Prasad sir, you talked about community welfare measure, and one of the interesting and important aspect of the bill is that community service is provided as a punishment for theft of less than 5,000 rupees. How do you see this?
I think I mentioned this in the beginning, because community service, for 5,000 less, if somebody is put into prison, and today we all read reports that how our prisons are overcrowded. There have been many reports which suggest that this kind of petty offences, people languish in jails. As it is, we are talk of overcrowding in jails. Then on top of it, the reports which talk about these people who are behind bars get exposed to antisocial elements and then take to a life which is far more destructive, problematic in the post. So I think this is kind of reduces the burden, and also community service will also work towards a larger social, many people talk about allowing these people away from the stigma of having undergone a prison term, but actually being made to do a community service. Thereby you actually make them accountable for what misdeeds they have done, petty as described by the law, and second, they remain part of the community and the society. I think this is how I look at it, Ashwini.
Right. And in the bill there have been certain archaic expressions like lunatic, insane, idiot that have been done away with. Do you feel that was also important and the changes were required? Shivaji sir, your take on this and the other aspects of the bill?
No, there are various aspects that we need to discuss, and no doubt, but within the time frame, of course, how much we can do that's a different issue. You see, the various kind of expressions that are virtually not very parliamentary. And if it is being done away with or makes some sense, of course, but sometimes what happens when these words are used and then what you do, again, you have to perhaps impose again some other penalties or some kind of act
Yeah,
that
I'm
the
here.
court often does, of course. So these things happen. But one thing I believe, again, in this on the new law provisions, you see, basically not everything has been made new. Most of the things that are already in the IPC that has been included in it. But of course, there are certain provisions like Section 377 has been dropped. And again, there has been re-included also into it that unless there is a consciousness on the act, it will again come under Section 377. Like those provisions are also there. So you see, much of what is happening actually is an evolving process in the law. So unless until this evolving process in the law is properly included in it, that is what exactly the new law has done. And you see, this is, I think, in these kind of issues, I think there should be a kind of a rule-based system how to include and update the law from time to time, because this has been an issue quite often which has been discussed that in the IPC, we have not been able to do it for long. So that is one issue that possibly we have to take care of, that how we can update these kind of provisions. Perhaps we can make an issue that every 3 to 4 years or 5 years, we can take, as per the observations of the courts, the police and other affected parties, these kind of issues should be regularly revised so that the law remains updated, and repeated amendment that needs to go for a very large process. It also involves lots of efforts and also finance. That is not required to do here.
Bharatiya Nagrik Suraksha Sahita, which will replace Code of Criminal Procedure Act, has one feature that is, it has been proposed that there would be in absentia trial, and it will be up to the delivery of judgment, besides zero FIR throughout the country. These features have been made part of the proposed bill. How do you see this?
Well, I think all this I said, Ashwini, much of it is because the experiences that the governments of the day and everywhere have learned from the various courts processes, the lacunas that keep coming up, that come in, that stop in place of carrying out justice. So this is what I think all these have been built in to the thing, both. And remember, these bills have gone through the Parliamentary Standing Committee headed by a person who held a very high position in police himself. So that allows him practical understanding of how the law plays out when it goes out. So I think all these have been incorporated, learning from the existing issues and the lacunae and making sure that it is more robust when it goes to the actual play. Ashwini?
Right. Prime Minister Narendra Modi had on Thursday hailed the passage of 3 criminal justice bills that will replace as many colonial era acts as a watershed moment in India's history. Shivaji sir and KV Prasad sir, you explained in detail different matters related to the bills that were passed in this recently concluded Parliament session. Thank you so much for talking to us.
Thank you very much.
You were listening to a discussion on important bills passed in the Parliament. The participants were KV Prasad and Shivaji Sarkar, political analysts, and Ashwini Srivastav, journalist. This program was produced and presented by the News Services Division of Akashvani. You can listen to it on our mobile app, News on AIR. This program is also available on our YouTube channel, News on AIR Official. You may share your feedback about this program through email at airnsdtalks@gmail.com or WhatsApp on 928-909-4044.
ये है आकाश